Okay, hi guys. Hi Joe, James, Martin. We might get some more people in a moment, but yeah, thank you very much, Sarah. Today, I'm just going to talk a little bit about, I suppose, trading online from a legal perspective. So look, before I get started, just a little bit about myself, who I am and what I do. So I hope there's actually quite a lot of information in this presentation today because it's a fairly complex area of law. But before we get into the meat of the presentation, just a quick overview of who I am and my experience and my practice areas. So I'm originally from Waterford, up to Dacia, but living in Cork quite a while now, and I'm married to a good Cork woman, and I went to UCC. So as every Cork person loves to tell me on a daily basis, I owe Cork everything, as it gave me both a wife and an education. I have two children, both under 3, and actually we have another one on the way in November. So very busy. And when I get a chance, I do enjoy cycling my bike, and you will find me somewhere out on the back roads of East Cork when I get a chance, as I say. So professionally, I trained in a large Dublin commercial law firm, and I also worked with Dell Technologies for 5 years, where I ran the EMEA software licensing compliance team. And after that, I went out on my own, and I ended up setting up an IP consulting firm where I helped companies manage their software licensing. And I actually sold that company at the back end of kind of 2018 to an American firm. And after that, then I decided to go, back into private practice. Long story short, I set up Cunningham Solicitors. God, it's a year ago now. It's a very fast year. And thankfully, it's been well received, and it's going from strength to strength. So, look, it'd be, I suppose, remiss of me not to mention the fantastic Republic of Work that is hosting today's event. I am part of the Republic Work community, and I'm also in the privileged position of being the preferred legal partner with the Republic of Work, where, as you can imagine, I help a vast array of startups navigate their legal challenges on a day-to-day basis. So look, guys, without further ado, let's get into the presentation. Now, here's a little bit of a warning before I get started. This whole area of law it's heavily legislated. So just, you got to bear with me on this one, because there's just a lot of law to get through, but you will pick up certain themes as we kind of go through it, which will be invaluable to you in your trading online business. So just talk a little bit about the agenda here. I'm just going to talk about the purpose of the presentation. Going to touch base on general consumer law principles, online sales law, enforceability of online contracts, IP and data privacy issues. I'm going to talk a little bit about company details that need to be displayed on a website. We'll talk about website privacy policies, website cookies policy, your typical website supply terms, and website disclaimers. Okay, so the purpose. So the legal landscape that's faced by businesses, guys, seeking to trade online at Irish and obviously by extension at European level, it's complex, it's continually changing, and it can often be bewildering, even for a legal practitioner such as myself. Most small to medium-sized businesses, they find it almost impossible to keep pace with the law in this area, and it's a very daunting task. So the aim of this workshop presentation today is to give you an overview of what I kind of call the main traps that you can fall into, and that you can easily find yourself in, pretty easily. So, and I'm a firm believer, and a lot of my clients will hopefully back me up on this, that my clients should be capable of identifying these legal traps or pitfalls themselves. And of course, you don't need to understand the absolute intricacies of the law. That's the role of myself, the solicitor, but you should know when in business to say, stop, take a step back before, making a particular business decision. Because and you have a feel for the law, that this is an area where I need to take some legal advice on, or I just need to be careful what I'm saying in this email back to a particular customer, for example. And that's what the focus today is, guys. It's empowering you, the audience, to recognize those legal traps before, like, you get caught up in them. Now, of course, the reality of day-to-day business is that things happen quickly. Can't always have your solicitor with you at your beck and call. Well, maybe if you're in Republic work, you can, but you need to be able, you need to be armed to make those decisions and have an awareness of the legal pitfalls that exist. And hopefully that's what you will get today from this presentation. Okay, so first and foremost, we're going to talk about consumer law. And this is the first, let's call it, bucket of law that we're going to talk about today from the perspective of trading online. So consumer protection law is a vast area of law and with many intricacies. And in a nutshell, if you're selling to a consumer, I can't overemphasize enough, guys, consumers, they're exceptionally well protected at law. And the kind of philosophy behind that is that consumers are seen as a vulnerable category of persons. And that's why they kind of deserve this special treatment at law. So I've listed here, 1, 2, 3, 4 primary pieces of legislation that cover consumer law. And I don't propose to go into each of them in detail because we'd be here forever, to be honest with you. But I'll just try and summarize them for you so that you get a flavor for what we're talking about. So first up is the Sale of Goods Act 1893 as amended. And this sets out the rules governing quality and other aspects of goods sold under contracts for sale, and also the remedies for the breach of these implied terms. Now, some of you will be familiar with these terms from maybe if you studied business studies for your leaving cert, or perhaps even your junior cert. Big shout out to my leaving cert business studies teacher, Mr. Quinlan. You should see me now, sir. And I told you I'd prove you wrong. I'm doing so well in my life. But so you will be familiar with these, right? So you've heard these expressions before. So, what are they? So the first employed term into a contract for the sale of goods is, it's really obvious when really you think about it. The seller has to have a right to sell the goods, and that's section 12, right? Under section 13, the goods must correspond to the description given. Under section 14, it's the kind of classic one. They must be of what they call merchantable quality and fit for purpose. And the fourth one there is they must correspond with the sample in terms of quality. Now, if one of these employed terms in a contract in relation to quality is breached, the buyer may reject the goods and treat the contract as repudiated and get a full refund of the price, or they could in fact claim for damages, and that's under section 11. Now, I use the word there, repudiated. That's a legal term, and essentially it means that the consumer could treat the contract as if it really never existed. So you can imagine it's important to meet these standards. Okay, so in terms then of controlling these employed terms or excluding them in contracts, there's a lot of people think you can do whatever you want in a contract and it'll be enforceable at law. That's not the case. This is a good example of why it's not the case. So different rules apply in terms of the exclusion of the employed terms for both consumers and businesses. And that's a very important distinction to get clear today. If you can take that away from this workshop, you'll be doing well. So pursuant to section 55 of the 1893 Act, any term in a contract for the sale which exempts the terms employed by section 12 of the 1893 Act shall be void. Now, section 12, as we remember, is that fundamental right, which is obvious really, that the seller has the right to sell. So you cannot in any way diminish or exclude that term in your sale of goods contract. Now, furthermore, where the buyer is acting as a consumer, as opposed to somebody in there acting in the course of trade or as a business, the terms employed by sections 13 to 15 of the 1893 Act, that being, remember, sale by description, merchantable quality, fitness for purpose, and sale by sample, they can never be excluded when you're dealing with a consumer. Okay, so moving along. So if we're dealing with a business, what can be excluded? This is kind of where it gets slightly a little bit complicated, but section 55 of the 1893 Act permits the terms employed by 13 to 15, which we just discussed, and to be excluded in a B2B or a business-to-business contract, now where it's shown to be fair and reasonable. Now, this is the major distinction between a consumer contract and a contract with a business. Okay, you can exclude those sections 13 to 15 where it's shown to be fair and reasonable. The next obvious question then is, what is considered to be fair and reasonable? Now, that's quite complicated and it's fleshed out in many cases, but there are some clues in the schedule to the 1980 Act around what is considered to be fair and reasonable. And if fair and reasonable is sometimes considered to be fair and reasonable, where it ought reasonably to have been known to or in contemplation of the parties when the contract was made. Now, the test, it can require the court to consider the reasonable expectations of the party, given the industry or area of commercial activity concerned. And in the schedule to the 1980 Act, it does set out a number of factors that regard can be had to, such as the bargaining position of the parties, whether there was any inducements given to the to enter the contract, whether there was a course of dealings between the parties, whether compliance was practicable, and whether the goods were adapted to a special order from the purchaser. So look, that gets quite tricky from a legal perspective around what's fair and reasonable. But if you just take from this today that can't exclude certain things when you're dealing with a consumer, you can when you're dealing with a buyer in terms of this sale of goods contract. Okay, this brings us then to the other area, which is the sale of services. So similarly to the sale of goods, you know, what can be excluded is dependent on whether you're dealing with a consumer or a business. So what are the actual employed terms when you're dealing with services? So, you know, the first one there is you have to have the necessary skill to render the service. The service must be rendered with due skill, care, and diligence. The materials that are used, they should be sound and reasonably fit for purpose for which they are required. And that where goods are supplied under a contract, they will be of merchantable quality, that is within the meaning of 14 subsection 3 of the 1893 Act. So you can see there's a little bit of crossover there in terms of the legislation dealing with goods when you're talking about services, because of course you can use goods in the supply of services. Again, so what can be excluded from when you're dealing with a consumer? So pursuant to section 40 of the 1980 Act, the terms employed by section 39, the ones that we've just discussed, they may be excluded from a B2C contract if the terms which purport to exclude the employed terms are specifically drawn to the attention of the consumer and they pass the fair and reasonable test. And in a B2B scenario where the contract is dealing with another business, any term employed by section 39 may be negated or varied by an express term of the contract or through a course of dealings between the parties or by usage. Okay, like just to kind of wrap up on that whole area, generally what happens then is that your supply terms it'll set out kind of when we're dealing with a consumer, this is where we kind of stand. When we're dealing with a business, this is where we stand. And you normally have what they call a severance provision in the contract that is designed to stop the whole contract falling down or being declared void, maybe where one of those terms goes beyond or not enforceable. It doesn't line up with the legislative position. So yeah, that's important. Okay, moving on to the next piece of law, which is the Consumer Guarantee Regulation 2003. So they apply in addition to the sale of goods and supply services and also the unfair terms regulations. And they require that goods sold under a B2C, we're dealing with consumers here now, guys, is in conformity with the contract, right? And any lack of conformity that is discovered within 6 months from the date of delivery of the goods shall be presumed to have existed at the time of delivery of the goods, which is under Regulation 8. Okay, so and any contractual terms waiving or restricting the right of the consumer under these regulations will not be binding on the consumer. So now we're starting to build up an idea here about how actually heavily protected consumers are. But wait, there's more. So moving along now to the Consumer Protection Act 2017 and 2014. This deals with what they call unfair commercial practices. So it kind of, in a nutshell, guys, it prohibits kind of sharp tactics, right? Unfair, misleading, and aggressive practices by traders, which are directly connected with the promotion, sale, or supply of products to consumers. So it provides that there's a range of unfair, misleading, and aggressive practices which are banned if they are likely to cause an appreciable impairment of consumers' ability to make an informed choice. So what does that mean? That kind of means like they pull the wool over their eyes, right? They think they're buying one thing and they're buying another. They think they're getting something and they're not actually getting it. So these practices are banned if they meet two conditions, and they are unfair, misleading, or aggressive, and they are likely to distort the consumer's choice. Now, actually, there's 32 commercial practices that are prohibited in all circumstances, and in fact, they do not actually have to meet the second condition, that is, that they distort the consumer's choice, and that these would include, for example, false claims that a trader is about to cease trading or moving premises. So, like if you're running a competition without awarding a prize, or false claims that a product can cure an illness is a classic example. Now, the Consumer Protection Agency, they have enforcement powers to ensure compliance with this act. And in addition, actually, there are in fact criminal offenses accounted for under this piece of legislation. Okay, so now moving a little bit away from consumer law, and we're going to move more into the general online sales law. Now, the consumer law that we just discussed, it also applies in an online context. This is just in addition to that. So I've sketched out a couple of the main regulations here. And again, I don't want to go into massive detail on each of them because it'll just take too long. And I'm going to just highlight, summarize each of them. So the Electronic Commerce Act, so what it provides for really is the legal recognition of electronic contracts and electronic signatures. Very important. Now, this does not mean that automatically an electronic contract is valid or enforceable. And as with paper contracts, you could still argue that, for instance, the contract has not been properly executed, or the person executing it did not have the relevant authority. And the same basic considerations around enforceability apply equally to the electronic contracts and paper contracts. Okay, so that's that. The e-commerce regulations 2003. So the e-commerce regulation, it provides consumers with increased protection when they enter into distance contracts. Now, we're going to talk a little bit about the distance selling regs in a minute. There's a bit of a crossover here between them, but like the distance selling regs, they impose various information requirements on traders. And this is the theme you're going to see here now. You're going to see prior information is very important when they're trading online. So what information is required under the e-commerce regs? So you're going to need to provide details of the technical steps required to be followed to conclude the contract, whether or not the concluded contract would be filled by the service provider, and whether it will be accessible, the technical means for identifying and correcting input errors prior to placing an order, and the languages in which the contract may be concluded. Now, importantly, all of this applies to both consumers and businesses. However, in relation to a business, there can be certain derogations from these terms, provided that both parties are in agreement, and that's provided for under Regulation 13. Now, moving on to the ADR and ODR regs 2015. So the online dispute resolution, the ODR platform, it's actually provided by the European Commission to help traders resolve disputes with their online customers without going to court, right? So it can be used for contractual disputes from online purchases of goods or services where the trader and the consumer are both based in the EU, Norway, Iceland, or Liechtenstein. So again, it's important to understand this. As a trader, you're not actually obliged to engage in this online dispute resolution process. And, you can refuse to accept your complaint through the ODR platform. You might want to take some legal advice on that, but that option is open to you. Having actually reference to the ODR link on your website, that does not automatically mean that you will engage in the process either. Okay. Now, moving on to perhaps what is the most famous of them all, right? And we'll all be familiar with this, the distance selling regulations. So the distance selling regulations, they provide consumers with increased protection when they enter into what they call distance contracts. Now, the classic example of that, of course, is when you're buying something online, but it can also occur where the trader is off premises. So where door-to-door selling is a good example. And this is where these regs kick in. So I do get asked about this. It's kind of like, why do these only apply like to consumers, or what's the rationale behind them? And like, as I alluded to earlier on, like the law presumes that consumers are in this kind of vulnerable category, and this is now exacerbated where the contract is included at a distance, and therefore you should be given additional safeguards, additional rights, such as what we see here, which is a right to a significant amount of prior information before you conclude the contract, and of course the famous 14-day cooling off period. So again, just to reiterate, the scope of these regulations, the distance selling regulations, they only apply to consumer contracts. That's the scope. And what prior information is required? So the distance selling regulations require certain information to be provided to the consumer. A distance contract will not be enforceable by a trader against the consumer unless the trader provides the information set out in Schedule 2. So what is that information? Well, there's a huge amount of it, really, to be honest with you. And I'm not going to get into every point. I'm just going to pick out a couple so you get a flavor for it. Some of them are obvious, right? So, for example, you've got to let the consumer know the main characteristics of the goods or services, the total price of the goods or services, inclusive of taxes, delivery costs where applicable. Maybe if you're dealing like on a subscription basis, the total cost per billing period or monthly cost, or the manner in which the price is to be calculated, perhaps the duration of the contract and the conditions for terminating the contract, the minimum duration of the consumer's obligations under the contract, where applicable, the possibility of recourse to an out-of-court complaint and redress mechanism and how to access it, where applicable, the functionality, including technical protection measures of digital content. So there's a lot of information there that consumers must be given prior to placing the order. Now, you must also give confirmation of the contract with the consumer. And we will be familiar with this ourselves, like when you're buying things off of Amazon and stuff, and you always get that kind of summarized email. So the trader must provide a consumer with confirmation of the concluded distance contract in what is called a durable medium. And look, that could be just a PDF or something, right? Or a link to a PDF that they can download. So this confirmation, it should include all the information we just mentioned above. However, if you've already provided that information to the consumer in a durable format prior to the conclusion of the contract, you've already met that criteria. Here's the big one, guys. There's a ban on pre-ticked boxes. You can't, have the box pre-ticked when a person is about to check out, sneaking in additional services or additional add-ons. You must obtain the consumer's express consent to any payment around additional payments, and pre-tick boxes, like they are a no-no, and they may cause consumers basically to inadvertently pay for extras that they do not require, and it's probably also seen as aggressive commercial tactics. Okay, so this now brings us to the famous cooling off period. So, like, what is the cooling off period? Like, so a consumer is entitled to withdraw from a distance contract without any reason and seek a full refund within 14 calendar days from the day the consumer receives the goods, or in the case of a service, the day the contract was concluded. And there's a little bit of a distinction there, so watch that one. So The duration of this cancellation period, this is interesting. It can be extended by up to 12 months where the trader fails to inform the consumer of the right to cancel the contract. Now, it's an offense for the trader to fail to reimburse the consumer. The right of cancellation, or the cooling off period, it does not in fact apply to some services, and some of you will be familiar with this concept. So hotel bookings, car rental, travel tickets, they're all specifically excluded, and contracts for the supply of sealed audio or video recordings or computer software that were unsealed after delivery, all excluded. Now, big one to get clear in your minds, guys, is services that have already begun with the consumer's agreement before the end of the 14 working day period are also excluded. And that's kind of fleshed out in regs 13 to 20. You'll be familiar with that, right? When you subscribe to Netflix and all of these services, you know, once you access those services, your cooling off period, it has been waived. Okay, moving along now to the enforceability of online contracts. This comes up a little bit in practice, and people ask me about this. And there's kind of two primary kind of online contracts that you'll come across: a click wrap and a browse wrap. So a click wrap contract is where the contracting party is required to scroll through and proactively accept a set of terms and conditions before progressing to the next web page. Whereas a browse wrap contract, it generally requires the contracting party to tick a box indicating that, you know, he or she accepts the terms and conditions which are accessible through a hyperlink. Arguably, I think a click wrap contract is a more effective means of bringing those contractual terms to the attention of the other party rather than a browse wrap contract. However, there actually was a Ryanair case, which is often cited as authority for the enforceability of browse wrap agreements, even under Irish law. But I would have a preference for a click wrap. And by the way, click wraps are sometimes referred to as click-through agreements also. Okay, so now we're on to our next topic, which is around intellectual property and data privacy. Okay, so copyright. So in the EU, websites are usually protected by copyright as long as they meet the criteria for copyright protection. And that criteria is basically they must be original and they must reflect the creativity or expression of the author. So copyright is one of my favorite areas of IP law because it actually arises automatically upon the creation of the work, and it actually requires no registration in order to be effective. So website content licenses. So during the process of, you know, designing and developing a website, like a website developer will probably have recourse to maybe different text, photographs, audiovisual, or software. And look, as we know, like the more interesting and dynamic the content on a website, the better the prospect of attracting the visitors. But, you know, it's a very, very important, right, that if you're having someone develop your website, that they're using third-party IP, right, that they have the correct license in place with such third party. Otherwise, you might inadvertently find yourself on the receiving end of an intellectual property breach notice from such third parties. Now, look, most reputable website developers, they have the correct licensing in place, and you should ask them to highlight that for you in your website development contract. Okay, company details. This one catches a lot of companies or businesses out, right? So where you've incorporated a company, right, under section 151, subsection 4 of the Companies Act 2014, you must include certain details on the website. And I won't get into all of them, but for the vast majority of companies, it's going to look something like, you know, the name and the legal form of the company, and that could be like ABC Limited, the place of registration of the company and the CRO number with which it is registered, and the address of the registered office. So you must have that on your website to be in compliance with the Companies Act. Okay, website privacy policy. Now, most websites, as I'm sure you know, it collects personal data on visitors, and consequently, most website owners will have obligations under data protection law and respect of such data. So the GDPR sets out minimum information that must be provided to individuals before collecting and processing their personal data. So website owners, you need to ensure that you're providing this information via a privacy statement or a notice or a privacy policy, whatever you want to call it, on your website. And Article 13 of the GDPR, it sets out the information that must be provided to individuals via such notice. And I don't propose to get into each and every one of them. I'll just pick out a couple. Maybe the legitimate interests pursued by the data controller or by a third party, an explanation of those interests, the third parties or categories of third parties, if any, to whom the data controller will disclose the personal data, details of any transfers out of the EEA, the safeguards the controller has in place, and the means by which to obtain a copy of them. And here's a big one: you must include the right to complain to the DPC if they are unhappy with how you are handling their data, personal data. Okay, moving along to the website cookies policy. So the e-privacy directive and implementing regs, they exist in parallel to GDPR. And like the e-privacy regs, what they do actually is it adopts the definition of consent under the GDPR. And this has the result that all of the conditions that the GDPR imposes around obtaining a valid consent must be met when obtaining an individual's consent to the use of cookies on your website. So what does that mean in practice? That basically means that your cookie pop-up banner, it must give users real choices around how they manage their cookies. And you will have seen this now as you go, as you browse and stuff like that. Now, you must also have a cookies policy, which lists out what cookies the site is actually running. And what I see is most people do that initially when the site is being developed and they have their website developer on hand, and it all gets populated and it all looks fantastic. But people, they forget to update their policy then, maybe as they add new plugins and the site starts running new cookies. So, keep an eye on it, on that. I know there's tools out there that actually you can get that will tell you exactly what cookies your site is running. So you can scan your website and get an idea of what's actually happening and update it as you go. Okay. Now, the typical website terms and conditions. So like the terms and conditions of a website, they should specify what users may do with the content of the site. Normally, this is limited to something like a right to print and download extracts of the site. Now, the website owner, that you should state that all rights, including all IP rights in the website, belong to the website owner. So give you an idea of some of the terms that will be included. I won't get into all of them. So maybe terms dealing with IP rights in the website content, which would also include a license from the user of any user-generated content. Big one, a limitation or exclusion of a liability clause for use of the website to the extent possible. This would normally exclude consequential loss and warranties, but any such exclusion will always be subject to the applicable law. For example, the implied terms in contracts for goods and services that we've seen under Sale of Goods, Supply Services, 1893 and 1980 Act. Maybe you would have a clause dealing with hyperlinks on the website, which will generally disclaim liability for the content of third-party sites. And you'd also probably have a disclaimer in there around, disclaiming any liability for the accuracy of the content on the website, because you don't want to be held to that standard. Maybe you have provisions then dealing with payment and other commercial terms, and you'll have standard boilerplate provisions as well dealing with jurisdiction, governing law and amendments, and perhaps even force majeure events. Okay, website disclaimers. So, it's critical for you as the website owner to disclaim any liability for the content or performance of the site. So, the visitor, you can't have a situation where the visitor is taking a case against you because they relied on the content which turned out to be incorrect or out of date. So as a website owner, clearly, you don't want to deliberately include such content on your sites, but it can happen, and you need to disclaim any liability for such an eventuality. Okay, now, with all of that being said, you will note that it's kind of a fairly fragmented area of law, and you're dealing with multiple pieces of legislation, and it's difficult to have that kind of helicopter view, so to speak. So what has been proposed is a scheme of Consumer Rights Bill 2021, and the government actually opened submissions on the content of the scheme. It actually closed 30th of June 21, so it will now move to the next phase of the legislative process. And so when this will be enacted, like, it's difficult to say, and maybe I'll cover it in another session, but like the purpose of it really is to consolidate everything into under kind of one umbrella, and it shows that the government have a clear plan here to reform consumer law in Ireland, in particular, including as it relates to social media, SaaS, and streaming service. So watch this space. Like what we've just discussed here, there may be some changes to it, but it's mainly an effort in consolidation, and with the addition of dealing with issues around social media and streaming services and SaaS that I just mentioned. Okay, so how can I help you? So, I do this day in, day out, so I can assist, drafting your standard terms of business, website terms and conditions, privacy policies, cookies policies. And look, guys, every business is different. Some will want to design a process around their standard terms being, agreed to as a click-through style contract, whereas others prefer the more traditional style approach, where you send out the terms via an engagement letter with the terms attached. My process kind of works something like this, right? I'll have an initial consultation with the client, where I understand your business and your challenges. I will draft the documents. You will review them, add commentary. I will redraft, and then I will send you kind of a detailed set of instructions that you can work with your website developer on, where exactly all of these documents need to fit on your site and fit within your process. And once everything is uploaded to the site, I then go in and I kind of review or audit to make sure that everything is as it should be. I offer a fixed fee on this service. So look, feel free to get in touch if it's something you're interested. So that's it, guys. A real whistle stop tour, what I believe are some of the key issues around trading online. I now come back to my original introduction, which is, as a business owner, you don't need to be the legal expert. You just need to be able to spot the traps and take appropriate actions. And in some cases, that would simply mean walking away from a contract, or maybe not transferring data outside the EU. And in others, it will mean you need legal advice. So I'm going to ask you questions now. I'm only joking. So fair play to James and Joe here for making their way through all of that.
Yeah, I was actually, I'm not going to lie, I was listening for most of it.
Okay, you see, you're covering yourself now, Yeah,
exactly. I've just been to a legal lecture, so I need to, that's what I've learned.
You've just, it felt like a law lecture.
Yeah, it's heavy enough going, but obviously it's quite important stuff. I was just kind of wondering, obviously we're early stage startups. Where we're at personally is we have a couple of paying clients. We kind of just got our first bit of pre-seed investment from an external investor and stuff, so we're just kind of spinning stuff up. And we have most of the stuff in place. We have our own solicitor, but we haven't got them to do a review of our website and that sort of thing. We've just got some standard documents off them, really. People that come, what stage do you typically see startups coming to you to kind of get all their ducks in a row in terms of having all the, because obviously if you're, when you're, there's a point somewhere where it's necessary.
Well, it becomes necessary when you're entering into contracts. So, yeah. But that's a kind of a dangerous game as well. And I've had conversations with startups where they're like, particularly maybe if they're a SaaS or a software business, and they're like, Dean, we really need to talk about our software licensing agreement. I'm like, we should do that now. Yeah, we should do that now. Oh no, we don't have the budget yet. And I get it, right? And then suddenly it's like, guess what, Dean? We just landed a huge customer and they want our contracts. And I'm kind of like, well, that's going to take a while, and you kind of lose a bit of face. Then it's kind of like you're slow to get your standard terms out. They should be at your fingertips, really. But what is it that you do, James?
So we do digital marketing software. So our own deal size with our customers isn't particularly big. So I think at the moment we're just getting a tenner off a month off for a handful of first paying clients. That'll go up over time. We're still kind of in closed beta with the software, so we're very early stage. It's like we wouldn't have contracts, you know, worth multiple thousands or anything like that.
Yeah. Like you should look at your, like what you call, like leave all the webs trading online stuff to one side for a second, but like you need to get your supply terms, you know, watertight. And, you know, you need to set out exactly what you're doing, what you're not doing, what you're responsible for, what you're not responsible for. And you need to limit your liability. We were talking a lot about limiting liability as much as possible, you know, and your solicitor should be very much aware of that concept. You know, like it's incredibly important to have those terms put in place, you know, ASAP. Even though it's a small contract, right? You can still get yourself on the hook for big amounts, and especially in the digital world. I'm sure you know, like I have people involved in digital marketing, and you know, there's sometimes they do things and the customers are not happy because they feel that they're down revenue from what they've done. You know, or they changed their processes, and it's kind of like there's no legal cases, but there's allegations being made. You know. You know,
you want to be covered in case that someone does take it the extra.
You want to be covered, yeah. Like I had a situation where somebody was developing a website, and they moved them over from an old website to a new website, and their SEO tanked, right? And they were like, "Why? Where's all our customers?" You know, and you know, this particular person did not actually disclaim that issue in the contract. They're not highlighted it, you know. You know, so sometimes the legal stuff, actually getting the legal stuff right, actually saves the relationship because it cuts off the arguments. You know.
James, just to remind you, Dean is one of our preferred partners in Republic of Work. If you're interested in office hours with him on a Friday morning.
Yeah, absolutely. I any Friday morning you want to, you know, slot in for a chat, just let me know.
Oh, yeah, thanks. I appreciate it. Like our solicitor is grand, and we have kind of a personal connection to them as well. So like, that's kind of why we're using them, but they're not like used to startup stuff. So
yeah, like, you know, there's
intentions, but stuff takes a while.
Yeah, I'm fast. Like, no, I spent years in Dell, you see, so like I'm kind of coming from that world. But like, you just need to be careful, and I don't know your solicitor at all, right? And maybe they know a lot more than I do, but they need to be specialist a business law solicitor, not somebody, a general practitioner, you know. Like I don't do conveyancing, family law, probe. I don't do any of that stuff. This is all I do, you know. Cool. Well, look, thanks for sticking with it, James.
No worries.
I hope you learned something. Like, I think the big themes are, you know, consumers. If you're dealing with a consumer, to be honest with you, you're nearly better off just to give them their money back, especially if it's a low amount. You know, because they go off to the Consumer Protection Agency, down on you like a ton of bricks, making your life a nightmare. It's just easy.
That's fair.
Yep.
Cool. Yeah. No. Thanks very much, dude.
No,
I want a one-on-one session basically, so it's grand.
What's that?
I basically got a one-on-one session, so it's
great. Yeah, exactly.
Nearly one-on-one.
Oh, damn, Joe's here.
Yeah. Dean, if I could ask, first of all, thanks very much. That was very informative and gave a good view of the legal considerations. My partner has I suppose it's business to consumer, or almost consumer to consumer. She has a website selling leggings.
Okay.
And I think most of what you covered, by and large, it's a lot of common sense, but I think she has just about everything covered. As you say, if she gets a request for a return, it's no questions asked, just to stay clear on that side. Just a quick question, just in terms of the contract, obviously is very important. And in terms of her website, which is very basic, it's a storefront and sales engine. Where is the contract in that arrangement?
Yeah, so it's a very good question. And remember, we were talking about all this idea of prior information. So the contract must be agreed to before they check out. Right? So you think about it, you know, you go, you add your things to your baskets, you know, you must be clicking, you know, I agree to these terms and conditions. And you can either have it as a hyperlink, right? Or you can have a more kind of in-depth process where they actually have to scroll through the entire contract and get down to the bottom and click I agree. But majority of people just have like a hyperlink with, you know, terms and conditions of business, and you know, you click I agree before you actually go and put in your card details. I would probably also put them in the footer of the website, just, you know, as a kind of a belt and braces approach.
Yeah, okay.
Does that make sense, Joe?
It does, yeah.
Yeah.
Thank you very much.
So yeah, it's just important that it's agreed to before they actually put in their card details, really. Now you will remember then that there's that concept of a confirmation order, you know, under the distance selling regs. So not sure what the process looks like, but ideally, like, you should be sending some type of an email after the order is placed, confirming what the order was and all of that good stuff, and maybe even that has a link to the terms and conditions.
Yes, so okay. I, as far as I know, as part of the full journey, there is no such agreement. So that's a finding from today. But
so like, it would be important to have that agreement, because, you know, it covers everything really, like around delivery and time commitments, liability, like the full array of issues under the distance selling regs. You know, you have to inform the consumers about their 14-day cooling off period. That has to be made very clear. And you actually have to, what I generally do is I kind of put a pro forma cancellation form at the back of the contract, so people know exactly how they can exercise their cooling off period. But the majority of people just send you an email, right, saying I've changed my mind on this order, you know.
yeah, okay. Thanks again.
Yeah, no problem. So like, your website really kind of has, you'll have your privacy policy on it, which doesn't sound to me like you're collecting much personal data. It just sets out exactly what you're using it for. You'll have your cookies policy, which sets out what cookies are on the site. You have your cookies banner, which allows people kind of, you know, manage their choices. And then you have your standard supply terms, which are really probably the most important document there, you know.
One that isn't there at the moment.
Yeah, and like that's when I get engaged to do people's websites, that's where the majority of my time is spent, looking at that.
Very good.
Good stuff. Excellent.
That was great, Dean. Thanks so much.
I'm coming up to ask you questions now, Sarah.
I just happened to be popping out for my lunch.
Thanks, guys. I appreciate your time. Cheers.
Yeah, thanks,
Thanks,
Andy. Really
Dean.
appreciate it.
Thank
No
you.
problem. Thanks, Joe. Thanks, James. Bye.
Thanks, guys.